Welcome to Decision Vision, a podcast series focusing on critical business decisions. Brought to you by Brady Ware & Company. Brady Ware is a regional, full-service accounting and advisory firm that helps businesses and entrepreneurs make visions a reality.
And welcome to Decision Vision, a podcast giving you, the listener, clear vision to make great decisions. In each episode, we discuss the process of decision-making on a different topic from the business owner's or executive's perspective. We aren't necessarily telling you what to do, but we can put you in a position to make an informed decision on your own and understand when you might need help along the way. My name is Mike Blake, and I'm your host for today's program. I'm a director at Brady Ware & Company, a full-service accounting firm based in Dayton, Ohio, with offices in Dayton, Columbus, Ohio, Richmond, Indiana, and Alpharetta, Georgia. Brady Ware is sponsoring this podcast, which is being recorded in Atlanta per social distancing protocols. If you like this podcast, please subscribe in your favorite podcast aggregator, and please consider leaving a review of the podcast as well. So today's topic is, should I form a B corporation? Sometimes also known, maybe more often known as a benefit corporation. And this topic is triggered, I think, simply because I find myself hearing about B Corps or benefit corps with increasing frequency. To be perfectly candid, I had never heard of one until about, I'm going to say 4 or 5 years ago, when I was retained to perform an appraisal of one that was a startup software company. And that's the first time that I had encountered it. And you know, it was novel. It was interesting. Anytime you had a chance to do an assignment, you learn something new as the provider. You know, that's always a good thing. And you know, I sort of filed it away. And you know, in the last few years, I hear B corporations being mentioned more frequently. They're talked about more often. I think, frankly, as more of the younger generation, whether it's millennials or Generation Y or Z, or I guess AA comes after that if you're thinking Excel spreadsheets. But you know, as more companies and company founders, I think, kind of reject the Friedman kind of notion where building shareholder value holds primacy above all other objectives. And we're seeing the pendulum kind of swing back to a stakeholder point of view, that B corporations have become increasingly important. And I suppose it's on my brain now because I'm trying to remember if they have been authorized in Georgia very recently, or they're on the verge of being authorized. And our guest will correct me there. I'm sort of spacing out on it. But we're about to be one of the states that allow this. And the majority of U.S. states allow them now, but not every single one. And, you know, they're kind of neat. And depending on what your desire is for a company you already have, company you're going to found, you know, this may be the first time you're hearing about a B Corp, or maybe maybe you've heard about it before, but you never really took the time to sit and research it. So this is your opportunity while you're driving or jogging or cooking or building birdhouses out of wood or tinkering with your car or replacing a graphics card in your computer, whatever it is you're doing while you're listening to a podcast. You know, here's an opportunity to kind of learn something more about it. And, you know, it's kind of interesting because, and this is the accounting geek in me, although I've repeatedly protested many times, I'm not actually an accountant. And it's instantly malpractice for me to call myself one. But you really don't hear of like a new kind of corporation or corporate form being created, right? You just assume that there are S Corps, there are C Corps, there are limited liability companies, partnerships, sole proprietorships, et cetera. And they've been around forever. And that number kind of isn't static. It's kind of like talking about adding a new state. It's like, oh, that's kind of cool. Where are they going to put the extra star? 51 is a hard number to divide well, because it's a prime number, but not a prime number, but it's a weird number. And so when a new kind of corporate form comes along, you kind of perk your ears up and say, oh, okay, well, here's something that's going to be a little bit different, a little bit out of the ordinary, a little bit novel. So I have told you now the sum total of my knowledge. I have literally spewed it out onto the internet in podcast form in terms of some knowledge of a B corporation. So as we do on the Decision Vision podcast, I'm inviting an expert on it. And joining us today is my friend Juliana Neelbauer, who is a senior associate at Eckl Farnham, a law firm here in Atlanta. Eckl Farnham is a full-service law firm that offers deep litigation experience, strategic corporate and transactional counsel, and practical legal advice to companies, individuals, and families. Juliana focuses her practice on virtual general counsel for-profit, nonprofit, charitable, trade organizations, high net worth individuals, and families which hail from the consumer technology, commercial technology, healthcare, industrial/supply chain, finance, government contracting, charitable, and political action industries. Prior to joining Eckl, Juliana was the chief operating officer of Ad Hoc LLC, a fast-growth federal prime contracting company that builds custom web portals to deliver government services more efficiently to millions of Americans by using agile software development and other modern web development methods. Juliana oversaw the scaling of Ad Hoc from a 9-person small business to a 90-employee mid-market prime contractor with a 10 times increase in revenue within a 14-month period. And the cool thing about getting to do these podcasts, I've known Juliana for a couple of years. I did not know that about her. I knew about Ad Hoc. I did not know that she led that kind of growth. So that's awesome. In the academic realm, Juliana has organized a legal clinic program for hacker participants of the University of Maryland's BitCamp, Georgia Tech's Hack GT, and University of Maryland's all-female Technica Hackathon events. She served for half of a decade as the attorney advisor to the executive board and entrepreneurs of the student-governed Startup Shell Incubator of the University of Maryland campus, and as a business mentor and lecturer for the MTech program in the Clark School of Engineering and for Fearless Founders classes at the Dingman Center for Entrepreneurship in the Smith School of Business at the University of Maryland. Juliana is a Penn undergraduate interviewer for the North Atlanta region and a past board member of the Penn Club of District of Columbia. Juliana, welcome to the program.
Thanks for having me, Mike. It is good to have you. And it's weird that we're not eating biscuits this time. I think that's when we first met. We got biscuits. And so that felt like the right thing to do when we were outside of Atlanta at the time.
Well, it was, and one of the reasons that I took an instant liking to you as well. So thank you for that. And I don't say that about many people. I normally take an instant dislike. So that's you're on the narrow side of the ledger there.
We'll see if we don't switch that before the end of the podcast, Mike. Well, hopefully we won't.
Well, right back at you. We'll see if we're still Facebook friends at the end of this. But let's start off very basic. What is a B corporation?
Sure. So a B corporation, as you pointed to at the beginning, is a new corporate form or a business entity, business organizational form. And what does that mean? On the most basic level, as a business owner, you have a choice of what kind of entity you want to form, its legal form, and then also what kind of tax treatment you want your entity to have. And the reason why you might form it is just because you didn't even mean to, but you just started engaging in business activity. And by doing so in certain states, that automatically makes a business arise around you and with you, whether it be a sole proprietorship that you never register anywhere, or a general partnership or a partnership with you and somebody else. And then some of us choose to actually register those things. And when you do, you have, as you mentioned, all of these choices, right? You have your corporations, which can be C corporations or S corporations for tax purposes. That's a tax status, actually more than a legal status. And then your LLCs, your limited liability corps, your various forms of limited partnership, your general partnerships, and then your nonprofit. And so those are the most common forms. Now there's a new kid on the block, and it's these B Corps or BLLCs or PBCs. And we can talk a little bit more about the differences if it would be of interest to your listeners.
I'm sure it would be. So we'll put a pin in that and come back to it. Can you sharpen my knowledge? I know there's something going on with B corporations in Georgia. Are they just about to be authorized? Have they been authorized? Where are we in our state for that?
Your instincts are right. We have passed both the House and the Senate in Georgia and the General Assembly have passed a benefits corporation law, which is Georgia House Bill 230. You can look it up online. It's available, and you can see the full text if you Google for the General Assembly site. And then the governor is in a period of review. And until August 5th, he may veto this bill, even though it was passed. And we don't expect that to happen, but Governor Kemp has done some things that have surprised business in the past, and so we'll see what happens. But the outlook and the prognosis from all of the policy wonks here is that he's either going to let it lie, which will make it automatically pass at the end of August 5th, or he will actively sign it in to put his signature on it and show that level of executive support politically for it. And one thing to note is that Georgia's law is not really controversial within the B Corp community. There is almost a trade, or some folks call it the benefit economy of businesses that are already engaging in this type of business. And so as each state decides whether it's going to adopt one of these laws, and is often being heavily lobbied to do so, they can add their own elements into each of these state laws. They can be a little bit different the way the corporate forms work, but Georgia's is pretty vanilla. So when we talk about what Georgia has passed in this podcast, it will apply to most of the other states that you would look at and sort of shop when you're thinking about where you might want to form one of these.
So how long have these B corporations been around? As we talked about, not too long, but how long have they been around, and do you happen to know kind of what state authorized them first?
Ooh, I knew you were going to ask me that, and then I wasn't 100% sure that I could tell you which state for sure, but I know that Delaware was one of the first.
Okay.
As normally the case, when you are trying to create something new in the corporate legal sphere, it's smart as a trade group to target Delaware, because the Delaware court system is older than our country when it comes to the corporate law that has been established there. And so, in fact, this is one of the primary reasons why shareholders, investors, and major businesses register in Delaware. It's not as many new folks getting into business believe, because the taxes are better. In fact, the tax rates are often worse when you're starting out in Delaware. There are tax advantages that you can capture once you've gotten bigger, and especially as you go public. But when you're a private business starting out, it's actually the corporate tax rates and some of the filing fees are much higher than other states. And so that's not why you pick Delaware. You pick Delaware because it's an old court system. And when you're in business, you like things that are old in the legal realm, because then they're predictable. And uncertainty is your enemy, right? Uncertainty means you have to spend more money to prepare for more contingencies. And that's expensive when you could instead know the future, know how the courts are going to rule, and either settle more disputes outside of having to go to court, or know exactly how much it's going to cost you if you do. So you want to target Delaware, and that's what we have here. So the Public Benefit Corp law in Delaware, or PBC form, has been established and has been around, I think for at least maybe over 10 years for sure. And the real movement and the push to make this a nationwide opportunity, where there was active lobbying in all state legislatures and organized lobbying to make public benefit corps, or really just B Corps, which is sort of the more common name for them now, to be pushed through, started in 2006, when one organization, a trade group called B Labs, was formed by three founders. I'm just going to go ahead and tell you that it's Jay Cohen Gilbert, Bart Houlihan, and Andrew Kasoy. And for those who are from the startup community, whether it be fashion or retail or traditional technology startups, you might recognize their names. They are the founders of And One, which was a very popular retailer that sold athletic wear, including shoes. And they had a very successful, growing, fast growth company that, unfortunately for them, once they got some additional funding in one of their rounds, they gave up control of their company, and their director, who was then made chairman, had so much power that he had a differing opinion than they did as far as how they should operate their company, and made some decisions that they felt were not in the best interest of society at large. and the environment, and that they felt would actually hurt marketing for their company and therefore hurt their bottom line. And putting all those three things together, once that company was sold at a price and at a stage that they felt was too early and too low, they were really passionate, even though they had some capital. So they said, well, let's actually fix this problem for the future. Let's create a legal shelter under which founders can let investors know and also legally be allowed to make decisions that aren't just to increase shareholder value, that don't just go to Milton Friedman's shareholder primacy philosophy and have the legal cover to do so.
So, and there's been some pretty significant uptake on this. I think one of the more famous early B corporations was also Ben and Jerry's, Ben and Jerry ice cream.
Yes.
And they would not consent to be acquired unless they were acquired by some entity that was going to continue to pursue a social mission, because that was always a big part of their culture.
Right.
And I think that acquisition kind of led to kind of legitimizing, if you will, for lack of a better term, legitimizing the B corporation. And now, if I remember correctly, I read in a Forbes article recently that there's over 2,000 of these B corporations around, at least.
Correct. And those are just the one. Well, there's more than 550,000 that are certified by B Labs. And they are, again, a trade group, but also a certifying organization. And so I should say, I believe that they have certified that more than 50,000 organizations are meeting the standards of what a B Corp would be required to do if they were a mission-driven or a purpose-driven organization. Now, I do not know if all of those are, in fact, registered as B Corps, now that I think about it. That might have been a nuance in their marketing that I would want to see. But to your point, there are thousands of these around the country now. More than 35 states, once Georgia passes its law, which we expect to happen again on August 5th, have these laws on the books so that you can form these. And so more and more of them are being formed every day. In my practice, I would say about maybe 30% of the clients who contact me to form a new business in the last year have asked me about B Corps and benefit corps and public benefit corps, and asked me, is there a benefit to me doing this for my business? And so we've walked through that analysis quite a bit in the last
30%. That's a much bigger number than I would have expected.
Yeah. And that might be my target audience, which is a lot of technology companies. It's a lot of second-time entrepreneurs as well. So they've had a nice exit. And now they really want to do the company, they want to operate it in the right way, fix all the problems from their last company, even if it was successful. And then they also want to have the company be more purpose-driven, because now they can do what they really always wanted to do, not just what they thought they economically needed to do. Does that make sense?
Yeah, no, it sure does.
Yeah.
It's that give back mode that a lot of tech entrepreneurs kind of enter once they've had that big exit.
Right.
So why, there's already a nonprofit corporate structure out there. Why is a B corporation needed? Why is there room for the B corporation to exist when a nonprofit organization exists, or maybe a for-profit but has a specific mission? Right? Take Newman's Own, where they've been very open that basically their profits, or most of them, go to various charities. I think mostly for sustainability.
Right.
Why was the development of a B corporation needed or welcomed when you sort of have a nonprofit structure already available?
Yeah, it's a great question. I think there's actually two different answers, and so I'm going to try to wear both of my business side hats and my law hat. On the legal side, there's a need for it because on the nonprofit side, you have a mission. It is defined. It must be defined in your charter. It is also something that you calculate against when you file your quarterly and annual tax returns to the IRS and then also to your state. And so it's very important that you are working within your mission. In fact, it can affect whether you maintain your nonprofit status or you don't. if you are not meeting certain thresholds as far as how much of your activity is falling within the parameters of your mission activity versus activity that's outside of your mission. And that can include both spending and also taking in of income. And so that's a very rigid structure, and can be hazardous if you are a new organization and you're not sure what that balance between your activities that you have to engage in order to keep your lights on, right, to bring in income into the organization, whether that is going to be sufficient on the mission side in order to keep your lights on, whether you're going to have enough donations when you're a new organization, you're unknown, versus activities that you can immediately generate revenue, but that might not qualify under the IRC for being within a mission. So, for instance, one of the quintessential ways that this trips up nonprofits is selling T-shirts or merchandise. Very often, you can't actually include merchandise sales for T-shirts or mugs within your mission, even if you just put your logo on there and you do it for a fundraiser. There's very specific rules for how you can do that and get away with that and not be subject to having reclassifying of that income when you go through an audit. And so that rigidity puts off a lot of organizations, a lot of founders, especially those who are maybe even sophisticated in business, but not sophisticated in law or tax law in particular. And they avoid the nonprofit form for that reason, or it just doesn't work for the scale phase of their organization. And so in that scale phase, they opt in for an LLC or a C Corp, which allows them to go after whatever revenue generation they can, helps them scale their organization, and then down the road, maybe they spin out, they form a separate nonprofit and fund that nonprofit with proceeds from their personal funds from the business and their compensation or through marketing activities of the business or what have you. But it's sort of and it's imperfect. And there's a friction there for those founders who have said, I want to be more true to what this organization is really about. I want to be more honest with my shareholders and my investors. I want to be able to be as honest as I can without creating liability for myself by saying, I want to spend 30% of the revenue that comes in the door, or at least of the net, the profit that comes in the door on social good activities, environmental activities, or I want to be able to opt overtly for the vendors that cost more in the supply chain, but that do better work, that don't use sweatshop labor for, the sewing of the garments that we produce or what have you. And so in those cases, there was actual legal liability that could arise, not only if you mismanage your nonprofit and lose your status because you're not perfectly meeting these requirements while you're trying to keep your organization alive, but then on the business side, if you have a for-profit business, there's a famous case where Henry Ford, after Ford Motor Company was wildly successful, and he's invested a lot in the city of Detroit and the state of Michigan. And while he was helming his organization, at one point he started to give out, double-digit percent of the net profit to these really, truly charitable aims throughout the city. And his shareholders filed suit against him and said, you're not following the Milton Friedman, course, and of course that Milton Friedman was later, but you're not increasing the value of the company with these actions. You knowingly are spending money where dollar for dollar, there is no chance that this is going to increase the value of the shares of Ford Motor Company. And so he said, I'm a brilliant man who's changed the face of the industrial economy in the United States. I've created one of the most successful automotive companies in history. I get to do this. I am Ford Motor Company. Come on, courts. I'm going to win this case. So he fought back. He didn't settle, took it to the courts, and he lost. And the court said, if you want to engage in charitable activity, form a nonprofit. And then we have the Ford Foundation as a result of that. So, cases like that and that's probably the most famous one where we talk about the responsibility of shareholders to increase their shareholder value. But it's a real risk. It's a way to pierce the protection you, as a director or officer of a company, have when you create your business entity and you register it and you get this corporate shield that protects you individually, and in your bylaws and in your operating agreement, if it's written at all competently, it will say in one of the last clauses in there that the company agrees to protect you and indemnify you for effectively making a bad call or having bad judgment in business, which in hindsight is very clear. But the problem is, if you do things that are overtly against creating additional shareholder value, or that are there's really no justification you can make other than I just did this for the good of the community, not for the good of the company, that can pierce your protection within your organization. It can pierce those protections in the company. And so if you look at those clauses, it'll talk about willful and wanton and negligence and willful and wanton activity where you purposefully do something that is not in the best interest of increasing the value of your company. Boy, now you can be sued individually by your own company or by individual shareholders and have these derivative suits pop up. And so it's a real risk on the legal side to take a significant portion of your business activity, of your time, of your team's time and energy to engage in activities that don't increase revenue, don't increase profit.
So that's good. That really lays out the case. I'm familiar somewhat with the Ford history. Ultimately he was also deposed because he was declared insane, and I have to wonder, with that story that you just shared, I did not know that background. I wonder if part of the reason his family tried to declare him insane was because he was spending money on that kind of stuff. Yeah. But so I think you've done, Frank, a really good job of explaining kind of the gap that a B corporation fills. Is it harder or easier to set up a B Corp versus other more conventional or more, I guess, just long-standing corporate forms?
I would say on the spectrum between setting up an LLC, which is probably the easiest form to set up. I mean, there's websites that will set this up for you, right, for a couple $100, and you just click a few buttons and they'll register it for you, and they'll create your corporate entity governance documents as well as make the filings, all the way to the, I would say, nonprofits or certain kind of exotic holding companies that might be offshore, where you have you're going to have an accountant and a lawyer and maybe multiple involved with setting up the initial company. That B Corps would fall somewhere in the middle, but probably closer to the LLC. It's really not that difficult to set them up. The reason why you will want to talk to an accountant or better a lawyer who's done one of these before or has been very familiar with the statute of the state in which you're going to register it is because they're new, quite frankly. And there are a few clauses that you do need to put in your articles of incorporation or certificate of incorporation, which is the formal attestation that you're going to file, the form that you're going to file with the state that you choose. And they're not vanilla. They're not the normal ones. It's not the template that you're going to find online. Some states have automated registration now for business filings, which is amazing and wonderful and democratizes the ability for people to create businesses, which I think is all a good thing. I would rather do less work myself as a lawyer on the front end of filling out rote forms and do more advising and have you spend your dollars and your time talking to lawyers to get real time and advice. And so anything that makes that easier for you to do, that, it doesn't require a ton of brain power from a lawyer or an accountant is good. But I don't know if all of those forms are updated to include those extra clauses that you really do want to include when you register a benefit corp, a benefit LLC, a public benefit corporation, whatever the designation is for that state. I hope that they would. There's also some, in addition to the minimum you'd have to have in there, which is an extra clause talking about the mission. What is that social good, environmental good, public good mission that your organization is going to be evaluated against as whether or not it is on mission, it is acting within its requirements to be in the public benefit. You do need a clause for that, for sure. And I would imagine that they would include that. But in addition, you're going to potentially want to add in your articles of incorporation a few extra statements to narrow the scope of responsibility of the directors and officers in this time where these are new, it is a little bit unclear how you're going to balance shareholder value with the best interests of those materially affected by the corporation's conduct, right? And then also kind of as a third category, the public benefit. Those are three different things. And so, that is one of the risks legally and also on a business level for anyone who is going to form one of these or going to operate or govern one of these, is making sure that you have set in writing how you plan to balance these three things. And in some cases, being more general could benefit you based on the type of business you're engaged in. In some cases, being very specific is going to benefit you because you're going to have a lot of professional investors who are going to absolutely hold your feet to the fire about this and not be day-to-day involved in your business and be understanding if at the end of the quarter or the year you haven't met what they consider success against that mission.
So let's talk about that, because I think I think that notion of the mission, I mean, it certainly sounds important. Intuitively, it's important. I imagine you cannot simply write a clause, or it'd be hard to write a clause in your organizational documents that say, hey, we're going to be a nice company and we're going to do good social things, full stop. I imagine you probably have to have some pretty specific language that defines kind of what that social, or maybe not social, that sounds kind of polarizing, but what your non-business mission is.
Right. Well, I think to answer your question, and we can actually look directly at the new Georgia statute, right? So let's use that as a template here. In Georgia now, once August 5th passes, and presuming Governor Kemp does nothing or signs this into law, either way, it becomes an effective form that you can file. You have to create a more objective standard for what your mission is and what success against that mission is than just generally saying we're going to do good for the world or we're going to do good for nature, right? You have to, no less than annually, give to your shareholders and any other person who requested in writing a written report talking about your performance as a corporation with respect to the public benefit or benefits that you included in your articles of incorporation. And by the way, your articles of incorporation are a publicly filed document, so they can be audited by anybody. And this statute sounds like truly anybody could have standing to say, I don't think you're meeting your mission. I don't think you're performing sufficiently, or have you even created this report? Are you in violation of the law? And if you haven't been creating these annually, then right there, you have a ding. You could potentially lose the right to have your corporate form. And that creates, most importantly, liability for you with your shareholders, so they could have derivative suits against you for mismanagement of the organization. And then within the report, well, what has to be in there? Georgia actually tells you have to create specific objectives for the board of directors in connection with that pursuit of the mission. It has to be there have to be standards that are defined, that are measurable, that the board has adopted, that show that the company is either progressing or not progressing positively in pursuit of those benefits. And then you have to provide some factual information that can be used to flesh out those standards. And so it can't just be a report with a spreadsheet with calculations that are not explained with effectively, history and facts of specific events that have occurred that support that the numbers are in fact tied to activities that occurred in the real world and had real effect. And so that alone, right there, it is a pretty heavy burden administratively compared to not having to do any of that. You have I mean that's really interesting. So I want to kind of put the brakes here and really dive into that, because I think that is so important. And I did not know that walking in, but on the finance side where I live, we have GAAP, right? We have generally accepted accounting principles that effectively is a common language that we pretty much all agree on in our society, at least in the financial world.
where, a dollar in revenue equals a dollar in revenue, profit equals profit, et cetera, et cetera. And we have a set of professional standards and even licensing for people that are experts in presenting to an external audience what the financial position and results have been for a company at a given point of time and over a given point in time, and commenting basically as to whether or not the financial statements can be relied upon. Now we're adding this new benefit statement, for lack of a better term. Maybe there's a term of art of which I'm unaware, right? And as you say, anybody can kind of make an objection and say, "Hey, I don't think that you're doing this, and you're doing this right." And it sounds like the burden of proof is on the company to prove that it's meeting its objective, that's extraordinary. There's very few areas of law, correct me if I'm wrong, that put the burden of proof on the defendant effectively.
Well, let's talk about that. So I want to say kind of, right? I said yes, but let's say kind of, because, what does this burden of proof mean? Like what I've described so far as these factors, these elements that you have to meet, that's about as detailed as the statute gets. And that was those are general statements, right? And so, yes, you have a burden to show that you've in fact gone through these steps and have some activity that shows that you have created objectives you've created objective factors and metrics and standards of what you're going to be graded against, and that they're going to be something that numbers can be applied to, and that in fact certain factual information responsive to those standards. Now I'm quoting the statute, factual information responsive to those standards regarding your success or failure in meeting those objectives has occurred. But beyond that, that's all the statute really says, right? I mean, I shouldn't say that. It just says a little bit more, but it's pretty general. And so there's a lot of what's maybe more interesting to you is not that the burden of proof is shifted. You have to show that you've taken these steps, right? And that you've done these things. What's actually interesting is that you suddenly have a new kind of accounting standard for this activity, right? In the sense that I think it's very likely that until the accounting community kind of jumps in on this and says, here's what meeting these requirements looks like from an accounting perspective, and we're going to standardize this, it will be non-standard. There will be a lot of different ways that organizations define their standards, define their objectives, and then define success. And like, how are the numbers going to define success? And so there will be a wide variance of what quote unquote is compliant. And so I say kind of, because just by showing you've made that attempt to comply and you have, checked off these sort of general boxes, you may in fact be in compliance initially until the accounting community just kind of defines what a standard really is and says it isn't a standard unless you're meeting this standard, right? The kind of expanded gap for this. And then the last part of this is you have to self-assess in theory. You have to, in Georgia, as an organization, assess the benefit corp's success or failure in meeting the objectives and accomplishing the goals based upon the factual information, right? The standards applied to the standards and the objectives. And so the real swirl that I'm seeing is it says an assessment. It doesn't say by whom. So in theory, you can self-assess, but it's risky legally to self-assess because we are in this gray area of what really is compliant. And until a court says you can't do something, it sounds like you can, but who wants to go to court and be the first company to be told by a judge, well, actually, that's the limit. You went too far. You're the one that's now going to get your hand snapped in the cookie jar lid, right?
Yeah, it's, having a case named after you is like having a disease named after you. You never want that to happen.
It's not a good look for anybody, and it's certainly not great for marketing. I mean, there's no way you can spin this as a good thing. So, I guess, somebody could say, well, we've now learned our lesson and we want to do it right. And we want to lead the way for doing it right. But the Georgia statute, it's clear in that there's these 4 prongs, right? You have to have real objectives, not just a mamby-pamby statement of a mission. You have to have actual standards that can be quantified. And then you have to apply actual factual information to those. to those standards. And then you have to assess at the end of the year whether you've succeeded or failed. Okay, great. But what does that really mean? So to your point, it's pretty squishy. It's pretty squishy.
So, I mean, are there standards being built up? Is there something akin to a gap for B Corps so you can have some sort of objective or at least generally accepted measurement stick? Is there an industry of experts, or are CPA firms being asked to step into this role? How is that shaking out right now?
Yeah. So yes is the short answer. And so let's flesh that out. The power of a trade organization like B Labs, which kind of is, I would say, like the leader out there right now, the most popular one by far, and is really the one that's put the dollars and the time in to lobby to get these state level B Corporation statute passed and to really make the movement happen within the business community. Their power is really great right now, right? Because they are defining what these terms are going to be, what these prongs are going to be for you to operate properly. And then at the back end, they do certification. And so when you hit the section that says you have to do an assessment, and then what does that mean? You go into a subsection of the statute, and it says, well, you got to it's best if you make your report more frequently than annually, maybe quarterly. You really should be making it available to the public. You should use some kind of third-party standard in connection with measuring where are you going to get that? Going to your question, how do I protect myself and make sure I'm doing this in a way that I can justify? Is there anybody else doing it? Can I analogize to something else? Well, they are providing all these templates to their members for how to do this. They're assessing you, and then they're also providing you templates for mission statements, for protocols, for creating standards. And so they have a lot of authority and control. And then in addition, they're getting either amendments to existing laws to make them in line with their standards that they provide, and then also getting, in states like Georgia, they're lobbying to get these new laws passed.
So this segues really very nicely into this notion of B Corp certification, because as I was preparing for this this conversation, I learned that it looks like there is a cottage industry of B Corp certification. I suppose B Labs is kind of a leader and a vanguard for that. So it correct me if I'm wrong, it sounds like that's what the role of a certification process is, I guess. Now I'd understood that to be to kind of bless a B corporation at the outset, saying, okay, you've got the right things, but do they also then perform a kind of audit or investigation or some kind of attestation to the effect that the company is continuing to meet its B corporation obligations?
Yeah. So every year, typically, you would have to, under like the B Lab model, you're having to provide them effectively the same kind of information that you would be providing to a state entity, typically, or like the IRS if you're a nonprofit. And so you would provide them with those reports if you want to get recertified, and then they maintain your certification. And so, yeah, it's almost as if they have privatized the regulator. And the idea is that's a good thing for you because they want you to get certified. Everyone's incentive is to make sure that you get certified and that you're doing this the right way, so that as a whole, they're creating this benefit economy and that you're all going to be able to participate in it, and then have on the back end, the membership has its privileges, right? You get access to all of these other benefit organizations that ideally can make up a supply chain that is very efficient for you and potentially helps you remain compliant because your vendors are also compliant, and so you don't have to audit them yourself.
Now, let's say that I'm listening to this and I'm thinking, wow, you're sort of hitting yourself in the head saying, I could have had a V8, but instead of V8, you say I could have had a B Corp.
Right.
And are you familiar with or aware of scenarios where companies have converted from some other corporate form into a B corporation, or is that something that's sort of exceedingly hard to do?
I have not personally converted an existing corporation into a benefit corporation. When that has been discussed in the past with a client or a potential client, typically it was easier in those specific situations to just create a new entity. But there's not, in most states that I have looked at, there's not anything that would block you from doing that, just like you could convert an LLC into a C corporation in most states, or even between states, and maintain the same IRS EIN number. So effectively, you don't have to always close one entity, pay back all of your investors their investments, and then, or, pay out to your investors what the value of the company is, split everything up, divide up the horses and the mules, and then reform something, which is 2 tax events, right? No one ever really wants to do that if you don't have to. There are ways to convert. And so, and there's nothing in the Georgia statute that I've seen that would block that. In fact, they have a clause or two that talk about what the voting minimums would be amongst your shareholders if they were going to take all of the existing stock in an existing organization and have it purchased by a B Corp or convert into a B Corp stock. And so I think they're planning for many organizations wanting to convert in Georgia from their LLC form or their corporate form.
Let me switch gears here, and I think you're really well qualified to answer this, because it sounds like you do a lot of advisory work on the front end of these things. What are some scenarios when maybe you talk somebody out of a B corporation, right? What are some triggers or characteristics of a company or a founder or something else around the company structure that says, appreciate you asking, but a B corporation probably isn't the way that I would suggest that you go? What do some of those things kind of look like?
Sure. I'd say anytime that you're in an industry that's already heavily regulated, often by more than one body or by a state level and then a federal level body, and that can turn your lights off with an injunction or an administrative action without you having your day in court, that type of entity, that kind of organization in that kind of industry is one where often it's not such a great idea, because what you're going to have is potentially a conflict between the responsibilities to your mission in some cases and maybe a regulation that you didn't even realize had been amended or changed, or an opinion that had come out from the regulating body that now makes your existing benefit corp mission activity in violation of your other industry regulation requirements. And so things where there's a lot of entities that are in the healthcare sphere are interested in this, because from a marketing perspective, it sounds great, right? We want to let everyone in the world know that, we're not a nonprofit, but we have a lot of the benefits of a nonprofit, and that we can act in accordance with a greater mission than just profit. But depending upon what part of the healthcare or medical device or medical services, medical research industries you're in, it might not be a great idea. It might be better to, again, either create a separate nonprofit that can engage in the activities that you want to be able to then show the community, hey, we're taking a percentage of revenue, and we have approval through other means from our board to have that go towards a nonprofit that's going to take care of those activities, right? And so that's a typical one. Another one is if you are in let's say a business where you have to do very fast growth, you're going to have to get outside capital. It's going to have to come from an investor community that is either deeply unsophisticated but very conservative and not aware of these types of entities already, and not understanding how they function and how that can affect their investment, the value of their investment, the multiples on their investment over time. Or if you're going after investors who are professional investors in VC funds, fund managers, right, who have a lot of LPs that they're responsible to. But again, it's in a very conservative industry where there's plentiful other investment targets that are in your same space that don't have the same structure. Anything in that case where you're not the vanilla option, you're not the option that it just fits their standard rubric of what they're looking for might mean that you don't get the meeting, or that you do a pitch and you never get a call back or an email back. And so in those cases where it's very competitive, you have a conservative investor pool that, it's so hard to get the meeting in the first place, to then spend half of your 10-minute pitch time educating your investor community about what your form is. Boy, that can be really inefficient when you really just want to talk every second about how you're going to change the world and make them tons of money while you do it through your business model.
I'm going to ask you an unfair question, and if it is unfair, just tell me. Nobody's going to hold you accountable for it. But I'm curious, have you ever looked into it? Have you ever heard of any studies that talk about whether or not B corporations actually tend to perform relatively well compared to their counterparts? I read studies from time to time that talk about companies with double and triple bottom lines that seem to do pretty well. And I'm curious if you're aware of kind of any learned information as to whether or not B corporations tend to enjoy some kind of performance advantage or not.
Right. No, well, Mike, my undergraduate majors were science degrees. So I'm a numbers person. I'm a research oriented person. And so this question doesn't bother me at all. Myself am very interested to see what the trends are with real numbers behind them on these organizations, and whether this really is just a marketing opportunity as much as anything else, or if there really are multiple players that can happen here as a result of choosing this specific form. And I have not seen a study that I felt was statistically significant. I've seen white papers that replicate or try to appear like they are scientific studies, but they are, I would say, still in the marketing realm, and they're anecdotal as far as the sample sizes that they're looking at. And so I think it's early days. This form has been around since 2006. We've had corporations in the United States that have been legally recognized since the 1600s. And of course, these corporate form goes back to the merry old England, even further. And LLCs have been around since mid-century of the 1900s. So, they've just these are the new kids on the block. They are so new that I don't know that we're going to have trend information that is really anything that you could rely upon for a while. I would say we got to almost give it 40 years minimum before we know whether that's just an overall economic trend versus some kind of benefit that this form has. That's me. Maybe I'm a little bit too scientifically oriented in that way, as far as wanting to have a big enough sample size. But I will tell you that I'm seeing objective shifts that could, in fact, create opportunities for these entities that other entities can't capture. And anytime that you make a choice on a business level that gives you an advantage and puts you in a smaller competitor pool, that's a good thing, right? That can only benefit you statistically over time if you have your other fundamentals of your business operation in order. And so, for example, there are grants that traditionally were only available to nonprofit organizations, that now there is movement to open those up to benefit corps and to benefit LLCs. By definition, if you're in a benefit LLC or benefit corp and everyone else in your industry is for profit and they can't access that capital, and it's a low cost type of capital to get a grant versus having to give out the very expensive over time, buying capital with your equity, or paying interest on capital that you get from other financial institutions. Boy, that's a real advantage. And I would expect that if that trend matures, where more grant organizations consider these almost like quasi nonprofits and allow them to compete for grants and major grants, then we will start to see that there's an advantage in that realm for sure. And then in addition, B Labs and others are not only trying to create the trade group to conglomerate and standardize what these organizations are, how they operate, how they evaluate success and performance, but they're also trying to conglomerate investor pools that are only willing to invest in these entities. And so if they are successful, then again, you've got a cartel. The moment you have a cartel, others can't compete. to get into that realm, now there's a whole tranche of capital out there that you can only access if you're a benefit corp, if you're a BLC. Boy, that should give you some kind of advantage over time if again, your fundamentals of your business are proper, if your market fit is proper, if your ability to execute is real.
Well, I'm planning on being around 40 years from now so we can check in on it, because I'm still waiting for my ticket to Mars. So, well, I'll tell you what, we will circle back in 40 years. We'll have another podcast. And assuming I have any marbles left at all, we will come back and check and see how B Corps did.
Sounds great. We'll do it from Mars. How about that?
We'll do it from Mars. Yeah. Well, we'll have to be. There'll be too much delay in the interview. So, Juliana, this has been great, and thank you for coming on. For those of you who are listening, we're doing sort of a late night recording here. This is late night with Decision Vision, and so thanks for staying on and staying up so we could get you on here. This has been fantastic. I have learned a ton about B corporations that I didn't know and probably should have before I valued them, but that's neither here nor there. If somebody wants to ask you, questions we didn't cover, would you be willing to take a question, and how can they best contact you?
Sure. Yeah. So I'm happy to answer questions about these. And if I don't know the answer already, I will track it down. I'm happy to do that. It's, education for your listeners is education for me too. I've heard a mixed bag of questions, so hopefully I can answer most of them. The way to reach me is through my email address, which I think is going to be made available through this podcast, but also I'm online almost everywhere because
it'll be on the website for sure.
Yeah, I'm on Twitter at Neelbauer and at Neelbauer Law. I think I have both of them on Twitter, 2 accounts. I'm on Facebook. I'm accessible via Messenger. I'm on every major messaging app, that you can imagine, because a lot of my clients are on all major apps. So I'm on LinkedIn as well. And the law firm is in these places as well. So if you can't remember my name, but you remember Drew, Eckl Farnham, either one is a great way to reach me.
Do you have a TikTok account?
I do have a TikTok account. Have I posted anything? Absolutely not. And I have removed the app from my mobile devices, even though I still have an account out in the ether, because the terms of service are ridiculous. And it is a backdoor for, you have given up so much of your data rights when you join that thing. And then it's extremely hackable, I think, by design. It's almost as bad as Facebook Messenger as far as the data rights you give up. But I think they're neck and neck for being the most atrocious online that I've seen.
All right, we will wrap that up there. A little bit of free information about TikTok, although I am disappointed I'm not going to get to see you post on it. But I would like to thank Juliana Neelbauer so much for joining us and sharing her expertise with us today. We'll be exploring a new topic each week, so please tune in so that when you're faced with your next executive decision, you have clear vision when making it. If you enjoy these podcasts, please consider leaving a review with your favorite podcast aggregator. It helps people find us so that we can help them. Once again, this is Mike Blake. Our sponsor is Brady Ware & Company, and this has been the Decision Vision Podcast.